SJC-13125, Stephen Foster and others, v. Carol Michi and others.
Okay, Attorney Tenoriello, please. How do you say your name? I'm sorry. Tenoriello. Okay. Oh, that's okay.
Perfect.
Okay.
Thank you, Chief Justice, and may it please the court. The question here is it deliberate indifference for the Department of Correction to refuse to use available steps to safely reduce its population when other steps it has taken to control the COVID virus have clearly failed? Now, the case law is clear that in the face of a known harm, a defendant who takes inadequate measures to address that harm is deliberately indifferent if the defendant refuses to take other effective measures that are reasonably available. And these cases are recited at length in our brief. The lower court had clear evidence that the Department of Corrections lockdown not only caused tremendous harm to people in custody, but it entirely failed to control the pandemic. About a third of the population has been infected.
Well, counsel, on the motion judge, in looking at his decision and what was presented, really focused on the fact that, at least as I read it, that the department did a lot here, and in particular, with the rates of vaccinations amongst the folks. When we decided Foster the first time, he made reference to the fact that it wasn't full lockdown anymore, that there were programs that were being available, and that they had opened up a lot more than they had the first time around. So in terms of kind of what was before the court, he made his decision. And is that decision an abuse of discretion?
Yes, Your Honor.
Just because he didn't agree with the way you were looking at those same numbers?
I'm sorry?
Is it because he didn't agree with the way that you were looking at the exact same thing?
In part, Your Honor, it should be noted that the Superior Court did not reach the question of whether there was a substantial risk of serious harm. It did not address that, did not reach that question. It noted that vaccines were coming and might resolve it, but it did not reach the question. Instead, what it did was hold that since the DOC had done a whole lot, that was good enough. And it relied exactly on this court's statement in the first Foster decision, where the risk of serious harm is substantial, but prison officials have undertaken significant steps to try to reduce the harm and protect inmates. Courts have considered there was no Eighth Amendment liability. That's what the Superior Court relied on, but that's only a partial statement of what the Eighth Amendment requires. The Eighth Amendment also requires that if those steps fail and there are other steps you can take to address the harm, you're deliberately indifferent if you don't. And at the time of this court's ruling, when this court made that statement, the DOC's measures had not failed. When this court made that statement, cases were down in DOC. This was in June of 2020. Cases were down, and the measures DOC was taking at that time seemed to be working. And what we know now is that they failed utterly after this court ruled.
Well, perhaps I have this wrong, but it seems that the main thrust of what you're saying here is they didn't release more people. They should have released more people. They haven't released more people. And because they haven't released more people, that's why the Eighth Amendment is implicated and has been violated. But the judge considered all of that. And the judge talked about how there were other things that the department, to tell the department just indiscriminately release folks is something that the court shouldn't do. And that given the discretion that they have with some of the measures that they have available to them, that they are in the best position to make those determinations. And so when they do, shouldn't that be accorded a little bit of weight here? And then isn't that exactly what the judge did?
I think where the Superior Court erred was in not recognizing the DOC's refusal to even consider using methods of safe population reduction that were before it. This court had said that, told the DOC in Foster and in subsequent opinions on stays of execution that it needed to reduce its population. The legislature had handed DOC tools to safely reduce its population, and the DOC turned its back on that, refused to even consider making use of tools for safe population reduction. The court, in the face of a constitutional harm, the defendant doesn't have discretion to exercise deliberate indifference, to fail to take necessary measures that are available. That is the exercise of discretion. It does not apply in the Constitution. The courts do not defer to a correctional administrator's authority in the face of a constitutional violation.
That's if we found one.
That's
Right.
right. That was this court's holding in Foster.
Right.
That if there is, if there is a violation, the court can order reductions. And after that decision, that is exactly what happened.
Just one clarification on one thing that you said, please. You referenced, and DOC did not use some of the tools the legislature, I think you might have said, recently gave them. We don't have that outside section of the budget that was passed over a veto before us right this moment, right?
Your Honor, it is in, it was before the Superior Court, and it is in the record here. It is, the law is appended to our brief, the budget law. And I can say very briefly that among the tools the legislature directed the DOC to review its population to see who could safely be released. And it gave it a couple of new tools, including, it said, you can award good time sentence reduction credits without any program participation. It said, you can award credits to people just for having been incarcerated during this public health emergency. The good time credits for those close to release, no such restriction on the public health emergency credits. So the DOC could have reviewed anyone for safe release. People who were close to release could have been given extra credit to get out sooner. People who posed no danger could have been given credits to get out sooner, but the department did not do that.
Are you suggesting that the plaintiffs get to decide how the DOC should act? The DOC has many different things that they could do, right? Why do the plaintiffs get to say, no, you should use this particular tool?
Thank you, Chief Justice. We're not attempting to tell the DOC how to act. What we're asking is that on remand, that the Superior Court take evidence as to the current threat that exists, and if necessary, craft a remedial measure that we have suggested a couple of benchmarks. For example, the ability to socially distance in sleeping and otherwise, architectural capacity of housing units. And we have suggested benchmarks for safety. There's also now a newly appointed ombudsperson whom, if they're geared up soon enough, might offer some standard. But we are not attempting to dictate how many. We are saying we need to. We are saying we need to find a benchmark. We're not telling DOC whether to use home confinement, whether to give good time credits. We're not telling whether to use the public health credits. We're not telling DOC who. We're just trying to say what is a safe level and what tools should the DOC be ordered to use to work towards that level.
Counsel, could I follow up on Chief Justice Budd's question to you? With this line item, assume for the sake of argument that now the DOC has these extra tools that the legislature has now given them. If they don't utilize those statutory tools now, does that turn into a constitutional violation, or is it just a separate and distinct statutory violation?
Both the failure to use the tool in itself is a statutory violation, and we have amended our complaint to allege that statutory violation, but we only raise it here as evidence of the DOC's deliberate indifference, that the DOC had these things it could have done and it refused to. So we're not saying that, if the DOC had released enough people on home confinement or through awarding full good time and boost time and completion credits to everybody who was in a program, if it had done that without making use of these new tools, but had reduced its population, then we might not have a deliberate indifference argument.
So then if you succeeded, what would the order look like?
What would
The order look like?
The court could order DOC to use these tools to reduce its population to a level that was judged safe based on the ability to socially distance in housing, or based on architectural capacity, design capacity, or a barometer of the court's choosing.
In other words, we would say a level of capacity that they should be at.
I'm sorry, Your Honor.
I'm just trying to get at what the order would look like. Would we be saying a level of, a percentage of capacity that they would need to be at?
I think, scientific understanding is evolving and the virus has evolved. So I think that would be before the lower court would be what level of population can safely be housed now.
Are there any further questions? Do you have anything else? I'm sorry, you've got time.
I would say, I'm sorry?
You have time. You still have time.
Yes. Well, I guess I would just want to emphasize that, this is very real in the prisons. Now, the record, of course, doesn't reflect this, but as community rates rise in Massachusetts and the Delta variant has arisen, we've already seen outbreaks in prisons just in August, and this is on the Department of Health website, so you can take judicial notice. There were 100 cases, between 72 and 100 in one prison in August, Susan Baranowski. And there were outbreaks in 2 other prisons just in August. We don't know what's coming, but we know that there's a serious danger on the horizon. We have presented substantial evidence that prisons are far more dangerous place than the community. Rates of infection in prisons are some 3 times higher than in the community, and prisoners are more likely to die than in the community. So I think, what the court should, this is just to emphasize the stakes in this case and the importance of remand so that the Superior Court can supplement the factual record before it to take account both of the vaccines, which we agree are a positive development, but also of the implications of the Delta variant, breakthrough infections, extreme transmissibility. So that's just to emphasize the importance of having the court look at this and apply. Again, I can't emphasize enough the importance of having the lower court apply the correct deliberate indifference standard, because if this court allows a standard to stand, which says, as long as the defendants do a lot, it's good enough, even if they don't do the one thing that could have prevented harm. If the court allows that to stand, I think it will have serious ramifications elsewhere in the law as well, of course, as in the prisons of this state.
I'm sorry. So you're saying, it sounds like you're saying there's only this one thing and they didn't do it, so it's deliberate indifference.
I'm saying they didn't do the one thing that we know is most important, which is allow for social distancing. The defendants themselves have admitted that on the record that people could not social distance, and they did not do the one thing that could have helped lower transmissibility by allowing social distancing.
Do you
Could have
think
saved-
really that's the one thing? Sorry. Do you think that's really the one thing, the social distancing, or
We know
maybe
that-
the evidence suggests that it is the vaccine?
Well,
Isn't that the evidence?
you're
I mean, all the
absolutely
scientific
right.
literature out there. Yeah.
Thank you so much for that correction. Vaccine, tremendously important. But in the face of the Delta variant and breakthrough infections, social distancing is still absolutely vital. And that's why we in the community are being told to socially distance and prisoners, unlike those of us in the community, they have to sleep in a room with others, who are not their immediate household. They're still in dormitories of 70 to 80 people. So they cannot self-isolate the way we can in the community, and they live in a far more dangerous situation. So I think the ability to socially distance in prison with the Delta variant remains vital.
Okay, thank you.
Thank you.
Attorney Dietrich.
May it please the court, Stephen Dietrich for Commissioner of Correction Carol Michi and former Secretary of Public Safety and Security Thomas Turco, now retired. I wanted to begin by updating some data points for the court, since the court in Foster indicated that current information is what's important, particularly in a motion seeking prospective relief from the court. Number one, on the issue of testing. To date, the Department of Correction has now conducted 50,941 tests. In the 30 days ending on March 20th, 2020, they had done 33 tests. In the 30 days ending August 21st, 2021, they had done 5,933 tests. Second, at the time of the filing of this, Commissioner Michi's brief with the court, the vaccination rate of inmates in the Department of Correction was 78%. It has risen now to 81%. In addition to the vaccination of inmates, I'm sure the court is aware that Governor Baker has issued a mandate that requires that by October 17th, 2021, all DOC employees must be vaccinated. Third, the current number of active positives among DOC inmates in prisons as of today is 0. There are 2 positives at MASAC, but those positives are the result of the patients arriving at the facility positive. So essentially, there are no active positives now. If that is an indication of the success of the efforts taken by Commissioner Michi and her staff, I don't know what is. I want to make this point about vaccination because my sister damns it with faint praise by saying it's a good thing. It's not just a good thing. It's a game changer. It changes the landscape. And the way in which I would like the court to conceptualize vaccinations is that it's constructive depopulation. In that if you have 80% of your inmate population vaccinated, then certainly for the purpose of serious illness or hospitalization or death, it's as if you took 4 out of every 5 inmates out of the system. Because the incidence of inmates who have been vaccinated encountering those issues, the data shows, is minuscule, absolutely minuscule. So if the issue in this case is decarceration, depopulation, vaccination is constructive depopulation.
Before you leave the area of vaccination, you said a minute ago that Governor Baker has issued an order and that all DOC employees have to be vaccinated.
All executive branch
All
employees.
is there no longer an exception permitting them to have COVID testing instead?
Not to my knowledge, Your Honor.
Okay, thank you.
obviously, there may be exceptions having to do with religious beliefs or medical issues, et cetera, but other than that, and the staff vaccination rate is now over 50%. I think it may be as high as 60%, but it will be taken as of October 17th.
On that point, the currency of that information, is there a legal challenge to that, though, by the union?
I believe there is. I'm not sure if the legal challenge has risen to the point of anything other than discussion.
I'm worried that if you want us to take that factor into account with a legal challenge, whether we should be doing that.
I obviously can't
Right.
future events. Something may come. The only information I have is here is the mandate. And, absent contrary information, I think the mandate will be honored.
Mr. Dietrich, do you agree that this outside section of the budget that passed with other available tools to DOC is before us in this hearing?
Only to the extent that plaintiffs assert that the violation of the statute itself constitutes a constitutional violation. And clearly, as a matter of law, that's not necessarily the case. Merely a violation of a state statute is not in and of itself a violation of the Constitution. If I could also speak, though, since it's been raised, to the particulars of that language. My sister has represented that there were tools created by this budget language which the commissioner did not utilize. I'm sorry, but that's simply factually incorrect. Whatever tools that were available have been utilized. To the extent that they haven't is because they either don't make any sense to do them or statutorily you can't do that. For example, there were 4 categories raised by this budget language concerning tools. One was home confinement. 3. One was home confinement, one was furlough, and one was the use of good time. Commissioner Michi has created a home confinement program, and in fact, she did so in the wake of this court's Foster decision, in which the court suggested that as an ask. There is now a formal regulation promulgated concerning home confinement. Inmates are now out on home confinement. The problem is, either as a matter of eligibility or suitability, the numbers are not high and will never be high, given who can be released either by statute or as a matter of commissioner's discretion. In the CPCS case, this court listed a number of offenses which constituted an automatic disqualification for releasing of detainees, presumably because they were dangerous.
That was actually you just didn't get the benefit of the presumption. It wasn't an automatic.
Correct. But if you were to just take those inmates who are committed under those statutes, that eliminates over 80% of the DOC population. The commissioner is also prohibited from using home confinement for inmates in medium and maximum security because they don't meet the statutory requirements. They have to be in minimum and in pre-release. And they also have to be released in the context of going or utilizing a work or vocation or education program. So there's a process in place whereby the entire inmate population is constantly screened by the classification committees in the department. And if there's someone who qualifies in terms of both eligibility and suitability, that person is then reviewed for home confinement. As I said, the problem is the numbers are low. As to the tool of furlough. The commissioner is prohibited from acting outside the furlough statute. The furlough statute limits inmate furloughs to 14 days. What possible solution does that give to the matter of COVID? One, they're coming back, and two, they may be coming back bringing COVID. So furloughs are no solution to the problem of COVID in prison. As to the matter of good time, absolutely, Commissioner Michi has used the tools available to her for awarding good time. She's created more programs. She's created boost time. She has created video opportunities for inmates to earn good time. She has completion credits, and she's awarded all those pursuant, consistent with the recommendation of, or the tool offered by the legislature. So it's simply a misstatement of fact to say that somehow she's not in compliance with that budget language, and therefore that constitutes a constitutional violation. She is in complete compliance with the budget language, and saying it, it isn't so doesn't make it so. I would make reference to the fact that also, Your Honor, my sister made reference to the ombudsman, which is also a creature of the legislature born out of the same budget language. An ombudsman has been identified, a contract has been signed, and the start date for that contract is September 1st. The charge to the ombudsman is to basically review the operations of the Department of Correction, both with regard to managing COVID in prison and also with regard to measures taken to depopulate prison. Commissioner Michi welcomes an unbiased, another set of eyes and ears to look at this. The ombudsman, additionally, one of his powers, his or her powers, is to recommend to the legislature, in the event that something more can be done or not enough is being done, a remediation plan. And also to call for the commissioner to testify before the legislature as to the state of affairs in terms of COVID and DOC. It seems to me that that pretty much covers any concerns about compliance with the budget language, doing what can be done additionally, if not necessarily, by the commissioner. So it seems to me to be an overlap, not to say that this court doesn't have jurisdiction to issue orders along those lines, but it seems to be quite a bit of overlap between the duties of the ombudsman and this court. Again, once you look at the infection numbers, I'm sorry, I wanted to make one other point about Susan Baranowski, since again, it was cited by my sister, and the fact that there was 70 to 100 cases. Well, there are no cases now at Susan Baranowski. And why is that the case? Because once the cases arose, the department did everything it could do and should do to manage the outbreak and to stop it from happening, stop it from increasing. I will also add, if this case is about social distancing, that's a bad example to offer to this court insofar as the fact that SBCC has 522 inmates. 494 of those inmates are single cell. So I don't know how much more the commissioner could do to socially distance than to put 98% of the inmate population at the institution where there was an outbreak in single cells.
But you understand, she's referencing social distancing across all of the institutions.
I understand, Your Honor, but the problem is each one of these institutions is a silo, right? Many of these institutions essentially have had no COVID. So, and in terms of social distancing, it's not a situation where you can take inmates from a medium security facility and as a matter of home confinement, release them to the population because those people are not suitable to participate in those programs. The people who are suitable are in minimum facilities. And if those people are eligible and participate in the home confinement program, that doesn't mean that you can just backfill from medium security facilities more people into minimum and pre-release, because those people are not suitable and eligible to go to minimum and pre-release. So there was this one outbreak, but I think it was managed masterfully, and it was done as a result of a host of tools used by the institution. It was the quarantining, it was the medical isolation, it was the testing. One of the things that the department does now as an embellishment to what they were doing a year ago is they do wastewater testing, which is extremely effective in identifying where COVID might exist. Inmates who needed to be isolated were. Inmates who needed to be tested were. There was an outbreak. The outbreak stopped.
Okay,
The active positives are zero.
I think, thank you very much.
Thank you.